May it please the Court, John Anthony on behalf of the appellant, CCP. This is a case that presents two issues. The first is whether or not no notice is good notice for purposes of subject matter jurisdiction in connection with a lawsuit by a record owner of real property rights against a municipality that has made an executive decision. The second closely related issue involves the question of whether or not an easement holder with record easement rights is entitled to procedural due process in connection with an executive decision of this kind. The Court recognizes, I think, that from the transcripts below, the Circuit Court judge deliberated very carefully, analyzed thoughtfully, but also signaled great deference to this Court and invited second DCA consideration. And this is that opportunity for us because it seems quite clear, given the history of this case, that our client, CCP, did not have any notice of the things that were being done to it in very much the same situation as you see, particularly Judge Silberman, in connection with the Neapolitan case. The facts of this case are fairly simple. CCP is the record owner of the dominant tract on Harbour Island, the North Tip, a retail center, the Knights Point, with Jackson's, with American Social, and with office tenants as well. It has a right for itself and for its tenants and their visitors to park in any one of 1,187 parking spaces within the nearby Crocker-owned Harbor 2 parking garage, so long as no more than 103 parking spaces are exceeded at any point in time. This is perpetual, 24 hours a day, 365 days a year. The problem, of course, is not that 103 parking spaces. The problem is that in 2014, Manor went under contract, the related entity, it's a sub of related group, went under contract with Crocker, the owner of not only the parking garage and an appurtenant office building, but also a 2-acre undeveloped tract. The 2-acre tract on Harbour Island sold for $14 million to Manor. Manor took back, in connection with the real estate transaction, the right to park 560 cars for its tenants or its users in the tower that was to be constructed on this 2 acres of raw land. 21 stories, 340 units with 35 parking spaces. You can see how miserable the neighborhood must have been to find out that this was going on. So the answer, as between the two private parties, Crocker, the owner of the garage and the transferor of the 2 acres to Manor, and Manor paying that much money for 2 acres of property, was that they were going to avoid on-street parking, which is impossible, by allowing all that parking to overflow into this parking garage, this finite parking garage, where we have rights to park anywhere. And not all the parking spaces are the same. For example, if somebody's parking because they want to go to Jackson's or American Social, they might prefer the first floor rather than the 9th floor.
But the easement that your client has doesn't specify particular parking spaces, correct?
Exactly. In other words, the first 103 cars in should be able to park anywhere so long as they're not already taken.
Well, but that's the key point, so long as they're not already taken.
Right.
So there's no guarantee that spaces on the first floor or any other floor will be available as long as there are 103 available spaces at a given time.
Well, and the problem here in this game of musical chairs is that when you add 74 easement rights that are other parties, not represented here, the 103 that our client possesses, 693 spaces that are allocable to the Crocker office building that I mentioned, as well as 560 spaces that were transferred under this shared facilities agreement, you're over by 243 the number of available parking spaces. So it's not a surprise that when we just add up two of the appellees here, There are no spaces available, and so...
In terms of the easement rights of your client, the issue is, are 103 spaces available, correct?
That's one of the issues.
And numerically, if everybody parked at the same time, there may not be 103 available spaces. But based on this record, based on where the city was in its zoning process, was that a speculative issue, or was that an actual existing problem that needed to be resolved in some manner?
Well, Your Honor, I think semantically we had addressed that issue, and I think it's fair to say that the tenants of my client's property, the retail center, and the tenants in the residential tower have not yet come to blows in the parking lot. There are a lot of reasons for that. The permit was issued, and the building was CO'd during the pendency of this litigation. The real point, however, is the absence of any notice in connection with an executive decision. So we would have gotten to those issues.
The absence of notice. You're talking about the absence of personal notice, as opposed to there's signage, there's mailing. I know your position is your client was entitled to more notice, but under the code, at least constructively, it received notice, correct?
Your Honor, we don't accept that proposition. We accept the proposition that we were entitled to actual notice, and we received not even constructive notice. Not only that, the framework of this ordinance is labyrinthine, but the truth of the matter is it imposes no real notice limitations on the municipality. If you take a look at 27-61I, there's a requirement of notice if somebody invokes the procedure for review. We didn't invoke that because we didn't know about what was going on, because it was a private decision. The permit was issued on July 30th, 2014 without any notice to our client, even though our client had an ownership interest of the subject matter. Now, the fact that later on...
The ownership interest being the easement, right?
Exactly.
Which is not considered a property ownership interest, correct?
It isn't under the ordinance, and I think that is problematic, because although notice goes out to residential owners within 250 feet of the subject matter, it didn't go out to somebody who had an ownership interest, a record title interest, right to park 103 cars anywhere in the building. We got no notice, and of course...
But is that a property ownership interest?
It isn't under this ordinance, but I think that's where you end up with...
And you've said that twice now. Is that a legally cognizable property ownership interest?
John, we think it is for purposes of notice and
Have you cited any authority that it is a property ownership interest?
No, because we know of no authority that hits this direct issue in this direct context. What we do know, however, Your Honor...
But that's an interesting argument, because easements are recognized and have been recognized for centuries. And so is there any case law, any statutory law that says an easement interest is equivalent to a property ownership interest? I know you have an ownership interest in the easement rights.
Right.
But is it an ownership interest in property? Has that ever been held?
Your Honor, not to my knowledge, and would be happy to focus more specifically on that if a supplemental briefing is required. But what I look to, and I think it's important, Your Honor, is that in the Neapolitan case, there was not even an easement right. And here's what this court said. It said, when you have parking credits, that was a case that involved a developer applied to the city and said, we need to develop the property, we need 75 parking credits. It's not even an easement. It's not even a real property right. And the city said, okay, we'll give you those credits if you develop the property. They then sent a letter, another difference from the case at issue, a letter to the adjoining property owner, Neapolitan, and said, by the way, 1/3 of the available parking in downtown that you're relying upon is now going to be consumed by your neighbor. And that letter...
And that was going to be exclusively consumed by the neighbor, if I recall?
Yes, and Your Honor, it's your opinion, it's your analysis, and what you said is parking credits, not even an easement, not even a real property right, allow that neighbor an opportunity to go in and challenge at circuit court level with direct action, not cert review, the decision of the city. Now, in this case, we got no letter. That was what the city of Naples did. That was a good idea. If the city had done that, if Manor had done that, then we would have participated in the initial round of community activity and that process that, of course, the appellees hang their hat on. That they want the city and its hearing process before Judge Pfeiffer to somehow present some sort of a sanitizing imprimatur on what happened. But the truth of the matter is, you don't have any procedural due process here because we had no idea of what was going on until the Shared Facilities Act was recorded. Significantly, the transaction itself didn't close until the permit was issued. So the integration of the closing and the changing of hands of $14 million was subject to something totally unlike the Neapolitan decision, because it said you do not have to, obviously you don't have to close until the permit is issued. Once the permit can only be issued to break ground if the shared facilities agreement is recorded. That happened in March of 2016, and by that point, the procedural process was well underway. It had been concluded, actually. Hearing Officer Pfeiffer had made his recommendation, and the City Council had approved it. All the while, the sort of notice that we're talking about might have been notice that would be important to residents who are worried about all the pedestrian issues, all the traffic issues, but not about the easement issues. See, what you have here is people mixing up the truth that residents have fundamentally different concerns and interests that would not have appeared on any notice that would have mattered to us as a commercial interest. So when somebody talks about 27-149C4 and whether or not an appropriate affidavit under the ordinance was issued, it wasn't an affidavit that instructed us that our easement rights were about to be dissipated. Significantly, for purposes of evaluating the Neapolitan question as to whether or not a quasi-judicial or or an executive decision has been made, 27-149A says it really doesn't matter if notice is provided. You can see that the appellees hang their hat on that. But the truth of the matter is that language exactly is what eviscerates the concept of a quasi-judicial process, because you need notice. It would have to be proper notice explaining that our easement rights are going to be vitiated, and it would have to be a deliberative process tied to that with findings of fact that were comparable to a judicial proceeding. In point of fact, when the code says, and this is 27-61J1E Romanet 3, when it says, you know, the City Council can evaluate, you can make some findings of fact, you can change some findings of fact, but you're not tied to anything. That's anything but quasi-judicial. What it is it's executive, and it's very significant that the whole process played out with a set of property owners. These are the alley plaintiffs who have homes on the island that have none of the same interests that we have. It's more than passing strange in the case below that what we had is the alley plaintiffs brought their case and they went with the hearing officer. The hearing officer made recommendations. The city, in the end, supported the decision to issue the permit. Then the first level of cert review occurred by the property owners with their concerns. Judge Isom thoughtfully said, you know, you should have involved the community more. It's a 177-acre parcel of land with 14,000 residents, a lot of commercial interests, 3 buildings in question, for example, and yet nobody really had notice on the front end. So having said that, it went to this court. The court PCA'd Judge Isom on that topic. But again, none of our issues were considered. Nothing about the easement rights and the fact that 560 spaces takes it to a floor level that doesn't exist, and we never even knew about it. So how could that be procedural due process? How could that be quasi-judicial? These issues are extremely tightly packed. Now, they're going to hang their hat on a federal district court case that was decided by Judge Hinkle, and it's accurate. The Manley case stands for the proposition that a site plan cannot interrupt or vitiate private rights. We accept that proposition. And this is a textbook example of why Manley makes sense. Because in this case, it's very circular reasoning by the appellees. They say, well, of course, you can't vitiate private rights with an executive decision of a municipality. Well, the truth of the matter is that's what happened here. So as much as we admire and appreciate that holding and that law, it's very circular reasoning to sit here and miss the obvious, which is that when our client bought the property in question and when its predecessors got the easement in question, there was no notice of any kind. Trying to say, citing 10 or 15 cases like the Battaglia case, it says that you're stuck with cert review of this sort of a decision, totally misses the point that what sort of a cert record would that be? You have somebody else's hearing about pedestrian traffic, about the impact on residences. We understand that. It's a really unusual parking program. In fact, the City of Tampa does not even acknowledge the Urban Land Institute analysis for shared parking and this sort of thing that is happening in the neighborhood. So any of us who are residents in the neighborhood object for all those reasons. But that's not the reason that we objected. We objected, and it's worth noting, when the City of Tampa first got sued in this case was brought by other homeowners comparably situated to the homeowners who brought the review process before Judge Pfeiffer. When Plyler, the second group, when they initiated the direct action in circuit court, it was originally in front of Judge Rice. There were 3 different sets of lawyers on the other side, and none of those great lawyers and wonderful law firms raised this issue of subject matter jurisdiction, procedural jurisdiction, and subject matter under somehow Article 1, Section 21, Chapter 86.01, 26.012. It seems pretty clear that there's subject matter jurisdiction for the court. This case was pending for almost 2 years before all of a sudden people said, well, maybe there's not subject matter jurisdiction. That's too easy. The bottom line...
Are you going to reserve any time for rebuttal because you're at 15 minutes now?
I'd like to reserve 5 minutes. Thank you, Your Honor.
Good morning, Your Honors. I'm David Weinstein. I'm with Greenberg Trarick. We represent Manor. A couple of housekeeping issues, if we may. The appellees have divided the time such that we will have 15 minutes, Your Honors, and the city will do 5 minutes unless the court has questions for Crocker, in which case Mr. Harrison is available to answer any questions the court may have. If I may have a 2-minute warning, I will move as quickly as I can through the 15. This case is about a site plan, as the court is well aware. It's a 340-unit complex on Harbour Island. It's fully constructed. Hundreds of people live there and call it home. The residents challenged the quasi-judicial site plan approval. Council has said quasi-executive 4, 5, 6 times this morning. We'll make clear that this was a quasi-judicial proceeding reviewable only through certiorari, and that's what the trial court found below and should be affirmed. The group of residents challenged the initial approval, and they characterized their challenge, Your Honors, as being a challenge to a quasi-judicial proceeding. They characterized it that way when they took the first tier cert appeal to Judge Isom, and they characterized it that way when they took a second tier cert.
But another party's characterization doesn't bind subsequent parties who may view it differently, does it?
It may not, Your Honor. But
so,
the point is
that's really somewhat irrelevant, other than Judge Isom's analysis was that it was quasi-judicial.
Right.
And we affirmed ultimately that decision.
Right, that's correct.
So one question on the easement, property ownership, property right issue.
Yes, sir.
I mean, it's clear that a party who holds an easement has some interest in use of the property.
Right.
Is that an ownership interest? And if not, what rights does an easement holder have to intervene in a process like this?
It is not an ownership interest in property, Your Honors. We can't find a single case that holds that. I mean, going back to law school, first-year property, it's a few sticks in the bundle of sticks.
It's a non-possessory interest in real property, correct?
That's right, Your Honor.
So interest in property then, under the analysis that you're giving, must necessarily be a possession of the real property, not a non-possessory right.
That's correct.
That's opportune to the property, correct?
Right.
And the easement existed, as Judge Silverman said. As I'm reading it, nothing changed about the easement. The easement existed before the site plan approval. It exists now. Nothing's changed. And we have right now a mathematics problem on parking, not a real problem yet. Is that correct?
That's right, Judge. And if I may make two points.
Is it not right, maybe? On top of no subject matter jurisdiction?
Well, you can look to the record below to see that CCP pursued a companion case, right? It stood before the trial court, Judge Stevens, and said, our easement rights have been eviscerated. And then sort of down the hall, although it wasn't down the hall, judges, because it's before Judge Stevens in the Complex Business Division, they had a second case in which they attempted to enforce the easement rights that at the very same time they said essentially didn't exist because we eviscerated them. Makes no sense at all. And by the way, Judge Stevens granted summary judgment in favor of the defense in that case, quote, without hesitation, close quote. Why? In part because of the point that Judge Badalamenti just made. There was never an allegation of an actual parking shortage. And the law, of course, as you well know, is you can't avoid summary judgment by saying something different in opposition to summary judgment than exists in your pleadings. And in their pleadings, they allege that there will be, in other words, in the future there will be some kind of a mathematical problem. But they didn't allege any present conflict, and I think counsel candidly admitted that there's no conflict in parking today. And what the court found below was, quote, one thing that never happened in this case, or in any of the other, in other words, parallel cases, as far as I know, is that any of CCP's clients tried to park 103 cars and had that 103rd car not find a parking spot. It never happened. So there was no actual parking problem, and there's no parking problem today. This was a quasi-judicial...
Let's turn to the notice issue.
Sure.
We know what the ordinance says in terms of the notice to property owners. Does the current lawsuit challenge the validity of the ordinance itself?
It does not, Your Honor.
So is the problem with notice, to the extent there is a problem, one that is appropriate for resolution in this case?
I don't think so, Judge. They didn't challenge the underlying ordinance. They challenged essentially the application of that ordinance. And the way the city applies it is very commonsensical. The city has to have a working way of knowing, who gets notice. And so
that's, again, there's public records of the easements. And I would assume that the parties, when this application was going through and the zoning people in the city knew that there were easements. In fact, they had to, because the agreement with Manor provides recognition of the existing easement.
Right.
So what methodology would there have been for CCP to challenge the adequacy of notice under the ordinance? Could it have done so in this lawsuit? Did it have to be by a separate lawsuit?
I think it could have done so in this lawsuit. It did not. It did not challenge the validity of the notice provision. And the notice provision, just so I want to make sure we're clear, has a two-pronged test. You have to own property, really three prongs. You have to own property. It has to be within 250 feet. And the third, Your Honors, is you have to be shown on the tax records, on the ad valorem tax records as an owner.
And that may be what the ordinance says. That doesn't necessarily mean it's right or that it would be legally upheld, but that's not before us.
That's not before you. No, it's not. And what happened temporarily, Your Honors, is that when the site plan approval process started and marched through, and by the way, It's not one person, it's not an executive decision, it's a woman by the name of Abby Feely and a committee of 20, and they kicked the application back 3 times. Okay, so it had to be amended 3 times before it was approved. When it was approved, CCP didn't own the property that it owns today. The property it owns is outside of 250 feet. It's the property where Jackson's and American Social. They bought it afterwards. They bought it in between the issuance of the site plan approval and the de novo hearing. But when the residents challenged the zoning administrator's approval, there was a redo. You started again with a de novo hearing, and that hearing involved all-day testimony. It involved everyone appearing by counsel. It involved 15 witnesses, 20 exhibits, almost 450 pages of documents, cross-examination, written closing arguments, and then a decision. To characterize that as anything other than quasi-judicial would fly in the face of this court's decisions in a number of cases, including the Hurt case set forth in our brief, and the Walgreens versus Polk County case that's also set forth in our brief. In both of those cases, this court was faced with the same procedural posture, and that was 1, initial decision by a zoning official, 2, a de novo hearing, 3, a decision by a circuit judge, and 4, both those cases came to this court, and the court reached the same conclusion, which was that those proceedings were quasi-judicial. The fact that they started with a zoning official didn't matter. What mattered was there was a de novo hearing in between. And in fact, Your Honors, in the Walgreens case, the court was faced with an argument that the proceedings weren't quasi-judicial because they were flawed. And what the county pointed to in Walgreens was there was no cross-examination, and fundamentally the witnesses weren't sworn. And this court held that you look to the law that establishes the quasi-judicial hearing, and does that and to determine its nature. And the fact that it may have proceeded in some imperfect fashion doesn't ipso facto transform what is clearly quasi-judicial into quasi-executive or quasi-legislative. You know, that's not the law of this court. It's not the law of the Florida Supreme Court, and that's the Hurt decision, Hurt versus Polk County, Florida. It's the Walgreens versus Polk County decision, and they are factually very, very close to this, both decisions of this court, and on point. And the Florida Supreme Court has said twice now, at least twice, more than that, I guess, that site plan approvals are indeed quasi-judicial, provided that they pass the test in Snyder, the earlier Florida Supreme Court case. And Snyder says 3 things. 1, has to be a limited number of identifiable parties and interests affected. This isn't all of the City of Tampa, it's not all of Hillsborough County. It affects a small portion of northern Harbour Island. Test Part 1 satisfied. Turns on facts arrived from distinct alternatives presented at a hearing. I've gone over the hearing with you. Clearly that was the case here, and a recommended order that went to City Council. And 3, Part 3 of Snyder is that the proceeding must involve the application of a policy rather than the setting of a policy. Here, the ordinance at issue, Your Honor, is 97-97. Unsurprisingly, it was passed by City Council in 1997, had been in effect 20 years approximately when all of this took place. And so what's at issue here is an incremental zoning review that occurred within the purview of 97-97. Now, had the City Council been passing a new ordinance, a different notice provision would be required. But this is not an ordinance, it's a resolution, and there's a 3rd DCA case directly on point, cited in our briefs, that says that the passage of a resolution is contrasted with an ordinance, can be done without notice.
Mr. Weinstein, you asked me to let you know when you had 2 minutes left of your 13, or was it 15?
It was 15, Your Honor, and if I'm at 13...
You've got 4, you're at 11. So
okay, thank you, Judge Silverman. Appreciate it.
13-minute mark.
Let me wrap up by addressing the due process claim and how that relates to notice. And this court has said on a number of occasions in Florida high school activities versus Bradshaw, and in Carmona versus Walmart stores, that Florida courts look to federal courts when it comes to analyzing whether there's been a due process violation, because the protections afforded under the respective constitutions are comparable. This court has said so twice. The Florida Supreme Court has made that clear in the Joshua case. So Manley, which counsel concedes is on point, so in Northern District case, the facts are eerily similar. You have neighbors. One neighbor took the position that a site plan approval of, they changed a barbecue place to a car wash, aptly called Suds, that the approval of the Suds site plan impacted his property rights and impacted the easement. Same as CCP's claims here. The Northern District made short thrift of it, dismissed with prejudice, saying, wait a second, you have your property rights under that easement are exactly the same after the approval of the site plan as before. There's no constitutional deprivation. Okay, the 11th Circuit reviewed, importantly, de novo, and reached exactly the same conclusion. And what the Florida Supreme Court has said in the Joshua case and his black letter law is, you don't get to notice, Your Honors, because notice only matters if there's been a constitutional deprivation. If there's been a deprivation, you move to the next level analysis, which is, was there notice and an opportunity to be heard? But if you haven't been deprived of anything that's constitutionally protected, you never get to notice. And that's what happened here. They were never deprived of anything, and you can tell it because at the same time they were complaining that their easement rights were eviscerated here, they were litigating the very same rights in a companion case. And that's what happened in Manley as well. There was a state court proceeding trying to vindicate the rights under the easement, Mr. Manley's rights, and at the same time, he was making a constitutional claim. The 11th Circuit and the District Court made short thrift of it. Judge Stevens below got it right, and we would ask this court respectfully to affirm the judgments below.
Thank you, Mr. Swanson.
Thank you, sir.
May it please the court, I'm Michael Colgan and I represent the City of Tampa. I want to finish up, and it won't take all of my 5 minutes, I don't think, with the point that Mr. Weinstein just made. If there is no deprivation here, then the question of adequacy of notice never comes into play. The city did not take a position below on the subject matter jurisdiction argument. I only argue the count one, which is the declaratory judgment count. And I, too, rely on Manley. And what Manley said, in part, is that this is a private agreement. If it turns out that your easement rights have been infringed, if you can demonstrate it, your dispute is with the party to the contract, not the city. And that's where the city starts and ends its argument. And beyond that, I have little to say that isn't repetitive, but I'd be glad to answer any questions.
The appellant puts heavy weight on Neapolitan. Do you have any comments about the Neapolitan case?
They cite Neapolitan, Your Honor, for quasi-judicial versus quasi-executive, and that's the point of the argument that the city takes no position on.
I mean, your view is this is purely quasi-judicial, and there's no real dispute?
I can't say any more than the city takes no position on this argument.
Okay. But the city's position, the city takes no position on it being quasi-judicial versus executive?
Yes, sir.
It says that your argument is that you don't even get there because it's not a constitutional deprivation in first instance.
That's our argument exactly, and the Manley case really turns on the easement holders' rights were never tampered with, infringed, or changed. They had exactly the same thing after the site plan approval that they did before, and that's exactly the case with CCP. Thank you.
Thank you.
The court has heard exactly what we expected. First of all, ignoring this court's decision in Neapolitan. Neapolitan is not some stray case. In 1935, the Supreme Court decided West Flagler. There was then DeGroote, Then Bloomfield versus Mayo. The analysis for quasi-judicial is there must be notice. Of course, there was none here. Okay? There must be a hearing. We were not invited to a hearing, and at the hearing in question, it is very clear that the residents who pursued that administrative line of review made all sorts of representations as to who had the easement, and they said that it belonged to Jackson's. They said it wouldn't matter. We didn't have notice. Now, the third element for quasi-judicial is that there be some correlation or some deliberative analysis, and there wasn't any. And the record that this court has on appeal, which I believe has been stretched a little bit in argument, is not going to show any real deliberative analysis that impacted our clients and any aspect of our easement rights. So the fact that we got no notice is not sufficient notice. Now, they avoid the obvious, which is that we got no notice that our own easement rights were being expunged. And then they say, but it doesn't really matter because, like the drainage case in the Northern District, Judge Hinkle's analysis in Manly, that we're really in the same shape. That was a case involved runoff, water runoff. It didn't involve the entire property being submerged and therefore unusable. And most importantly, it didn't involve any of the Neapolitan facts, which are extremely right on point. And all the court needs to do is analyze Neapolitan, recognizing that it did not involve an easement right, like our record easement rights. In that case, the municipality was kind enough to begin with a letter to the most interested party, even though it didn't have an easement right. The similarities are, the alternatives are off-site parking or truncate the size of your business. So that, or impact and challenge the executive decision. There's no way it can be anything other than executive decision, given that it does not conform with any of the requirements of a quasi-judicial decision. It would be like saying that somebody who got no notice of the briefing schedule today, somebody who got no notice as to when the oral argument was going to be, someone who had a real dog in the hunt as far as the dispute, somehow could be bound by a determination by this court. That isn't quasi-judicial. That would be an error. And, of course, counsel wants to glide by that because the truth of the matter is, and you can see it right after the PCA in the litigation below, the litigation before this case was begun, the Plyler litigation. The Plyler plaintiff's not here today. But the big picture is, in that case, as soon as this PCA was entered, the mayor congratulates Related on taking care of this. Well, they're very much in communication with each other. The discovery showed it. Is it collusive? I don't know, because we didn't get a chance to get past, we didn't get an answer out of them. We're losing on summary judgment and on a motion to dismiss. We should have had the right to continue the case and find out what the mayor meant when he said, I'm going to send out my Irish mafia if anyone else challenges this building. But we didn't get that chance, and that's the problem with saying that this is quasi-judicial. We had no idea it was going on, and there's no way to call that quasi-judicial. So that's where we are in this process. As far as the damages, we did have another case going, and of course we beat Manor because they said that their rights were out there and that they didn't want a determination that our rights are senior to theirs. But that doesn't solve the whole problem. There were 4 counts here. We haven't gone to trial on any of those counts. We deserve a right to be heard. We deserve a right to appear in front of a jury, present our damages. There are damages when you own a piece of real property that's a couple 100,000 square feet that contemplates parking for all your tenants and all their guests, and you're shut out of 103 spaces. I wish I could speak outside of the record to speak about the entire other case, but I can't, because that's not what's on appeal. What's on appeal is two threshold issues that's all this court has to consider, which is subject matter jurisdiction in light of a Neapolitan-type scenario, and whether or not we got procedural due process. You don't have to get to our damages today. You didn't get to the
That
damages in
brings us to the
Neapolitan.
end of the time, Mr. Anthony.
Thank you very
much.
much, Your
Thank
Honor.
you, counsel.
Thank you.